We're here this morning to point out some very alarming statistics which are impacting victims of very violent crimes and their families. And we are also here to call for reforms and oversight with regards to the unelected Connecticut Pardon and Parole Board. Consider this. In 2021, the board granted one commutation. In 2022, it commuted 95 sentences for 71 felons. That's right, 95 sentences for 71 felons. Those 71 people are symbolized by the 71 silhouettes that are on display behind us, also indicating the crimes for which they were convicted. Most notable is the one in the upper right corner from my perspective, left from yours, 44 who were convicted of murder. These are very violent offenders. These are murderers. They are getting decades and decades taken off their prison sentences. In 2021, 18 inmates applied to have their sentences commuted. In 2022, 431 applications were submitted. What I'm holding here are 41, a mere 10% of the applications that were submitted, and obviously not even as many of the people whose sentences were commuted. So the question is, what's going on? Why is this happening? And what are the victims' families asking? They're asking those questions, and so are we. Today we are calling on the governor to ask the same questions because they need to be asked. We are calling on him to suspend commutations until the administration can explain the reason for the astounding increase in commutations, especially in light of Superior Court's ability to modify sentences has been expanded over the past year. At this point, I would like to turn the program over to Senator Heather Summers.
Good morning, everyone. I wanted to talk a little bit about what commutation is, and it is the reduction of a sentence or punishment given by the court of law. It's usually granted by the executive authority, such as the president or the governor. When the public thinks of commutations, they often think that they're granted for humanitarian reasons, when someone has almost served their entire sentence and perhaps they have a terminal disease and little time left. It should be extremely rare. They are not thinking about what's happening here in the state of Connecticut. They are not thinking that we are shaving decades off of criminal sentences. We are not thinking that we are allowing violent criminals to have these sentences reduced and commuted, leaving the victims to be re-victimized and endure reliving their tragedy, in some cases every 3 years. This is what's happening right here in the state of Connecticut, and it must stop. Commutations took a drastic shift in 2021 during COVID by the Board of Pardon and Parole by updating their policy on commutations. In the years before, or the 5 years before, there were 5 commutations. Last year, there were 65 alone for murder. And just recently, the most recent meeting in February, someone named Mr. Watts had 67 years commuted from his 95-year sentence. Those who commit murder are one of the most heinous crimes known to society. They have taken the life of another human being, a crime that is universally condemned. The punishment for murder is often severe, as it reflects the severity of the crime, and therefore it's difficult to imagine granting commutations to individuals who have committed such a crime. This is even more troubling in the case of a plea deal. when a defendant pleads guilty and accepts the sentence that has been carefully negotiated over months, even years, with a number of people participating. The sentence takes into consideration the severity of the crime as well as other mitigating factors regarding the defendant, such as a criminal history, family history, social and educational history, substance abuse, mental health evaluations and concerns. And additionally, the victim is given an opportunity to provide input on the deal. It's also been noted by Chief Attorney Patrick Griffin that most of these commutations that are granted, they're granted over the objection of the family and the state's attorney's office. Serious offenders leave trails of victims in their wakes. The victim's family and friends are left with the pain and the trauma of the unimaginable loss, and of course, the loss of the life that could have been, if not for the murderer. Granting a communication to a murderer sends a clear and poignant message that the life of the victim is not valued. It diminishes the severity of the crime and can cause additional harm and trauma to the victim's loved ones for years. Commutations for murders and serious offenders can and will undermine the public's trust in our justice system. I have already had numerous phone calls expressing outrage on this policy, which was written in the dark without any legislative oversight, input, or notation. And it has allowed 65 serious criminals to have their sentences commuted in this state just last year. Again, with the members of this board being lay people overriding the deliberate and countless work of the sentencing judges in these cases. It's simply outrageous this is happening in the state of Connecticut. The public expects that murderers and other serious offenders will be held accountable for their crimes and that justice will be served. Granting commutations to these types of individuals makes the public feel that the justice system is failing by not fulfilling its duty. It also creates a sense of injustice, particularly for victims and for their families. Lastly, commutations for serious offenders and murderers can set a dangerous precedent. It can send a message that murder is not a serious crime and that if you murder, you can get time away with a lighter sentence. This can have a ripple effect on society with potentially dangerous consequences. And while there are some extreme cases where individuals may be warranted, these cases for commutation should be rare, not commonplace. And the arguments against commutations for murders and serious offenders is a strong argument, and it must be considered carefully before granting any such request. We must remember, and we can never forget, that murder and these other crimes are serious offense, and justice must be served for both the victim and their loved ones. I thank you for listening, and now I'm going to turn it over to Audrey Carlson.
Good morning, Senator Heather Summers and other distinguished legislators here with me this morning. And good morning to our friends and our family who are here today. We wouldn't be here without your support, and thank you. Thank you, Senator Summers, for having this press conference to draw attention to the recent actions of the Board of Pardons and Parole regarding Commutations Policy 11102. Good morning to all the people here who walk in my shoes. My name is Audrey Carlson. May 22nd, 2002, our daughter Elizabeth Carlson was viciously murdered by her ex-boyfriend in our home, inmate 300990. Elizabeth was just 24. We are serving a lifetime sentence, and he is serving a 42-year sentence with no parole or good time. There is no question as to his guilt. Our daughter Leslie was present at the killing, and one of her friends, Newington police officer Mike Morgan, apprehended the killer running down the street, truly with the smoking gun on his person. The crime was breaking and entering, lying in wait to ambush a carefully calculated, planned, and executed premeditated murder. killer immediately confessed. If the case had gone to trial, there's no question he would have received a 60-year sentence, but he would have been able to appeal over and over again, with our family reliving the trauma and the pain, triggering PTSD. We reluctantly accepted the state's attorney's recommendation of a 42-year plea agreement. This contract was clearly and concisely stated and understood as ironclad. Not one day less, not one day more. He would serve his sentence in its entirety. 30-some-odd years ago, survivors of homicide fought very, very hard to assure that a sentence for murder would be no good time, no parole, no pardon. Commutation didn't even exist in anyone's imagination. June 1st, 2021, the Board of Pardons and Parole instituted a revised commutation policy, not a law, a policy, not voted on, as a way to get around the ability of the state's attorney's office to veto sentence modification requests. There needs to be accountability in terms of having the commutation applications be screened by the state's attorney's office, then ultimately landing with the BOPP. A 3-person unelected panel solely determines the fate of the incarcerated. Why are the state's attorneys and judges not involved in making these critical decisions, keeping society safe? This has to stop. First and foremost, we put our trust in our leaders in government who take an oath to keep us protected and safe. We need transparency in informing the public. Many of the legislators we met knew absolutely nothing of this commutation policy. Most people didn't know anything about this. This is wrong. We are members of the club nobody wants to belong to, the survivors of homicide. Many people think bad things happen to someone else. Guess what? We are the someone else. Imagine the unimaginable for just a second. Your world crashes in around you, you're caught in a riptide, you can't breathe, and just when you think and you feel that you might find your way, you learn your killer can be set free. We buried Elizabeth 21 years ago, and now it feels as if we're right back where we began, reliving the worst nightmare of our lives. We have lost trust in the judicial system and want to believe that you'll make this right. Connecticut is turning its back on survivors of homicide victims. We matter. I maintain if you see something, say something. Words oftentimes get lost and are meaningless. We're here today to put those words into action. On behalf of my family and all of the victims and survivors of homicide, I am pleading with you today to abolish the inequities of the revised sentence commutation policy. Thank you for letting me speak today, and I'd like to introduce a very dear friend and another member of the club nobody wants to belong to, the survivors of homicide, John Aberg. Thank you.
Thank you, Audrey. My name is John Aberg. I'm here because we had a murder in my family, and I am very concerned about the increase in the number of commutations, even for those who committed violent crimes, even murder. 16 years ago, my grandson was murdered. His name was Andrew Slider. We called him Andy. Andy was 3 years old. It was an incomprehensible crime. The person who molested and savagely beat him to death accepted a plea agreement to plead to murder 140-year sentence. He knew that he would face far more time if he went to trial. For example, the state would not have dropped the sexual assault charges that they did drop in order to come to a plea agreement. And he would have ended up with far more years. We were assured that as part of the plea agreement, he would serve the entire 40 years. The phrase used was day for day. It was a contract that both sides agreed to. The sentencing judge said this was a senseless, anger-motivated homicide by a deeply depraved person. The judge worked with prosecutors and defense attorneys to reach the agreement, and he said that it was a reasonable agreement short of trial, a reasonable resolution short of trial. And he said to that child killer, quote, "This is a sentence you should not outlive." Now we are told that that plea agreement may not stand at all. We're told that this murderer can apply for commutation right now. We're told that a report, you heard some statistics here, 2021 to 22 shows that more than 80 people, more than 80 people convicted of violent crimes, including murder, have been released early with a commutation. In that process, that commutation process, these killers do not even have to serve the mandatory minimum sentence. We are ordinary people. There's nothing special about us. We stand in front of you as living proof that this can happen to any family. My family left the courthouse that day with the understanding that the monster who murdered Andy would be kept apart from all of us for 40 years and kept apart from all of you and your own children and your own grandchildren for 40 years. I don't understand how this can happen. How can just 3 people in the Board of Pardons and Paroles override the deliberations of a court that spent years working out an agreement? If the board wants to consider shortening the sentences of nonviolent criminals, maybe even some manslaughters, or for individuals who were younger when they committed their crime, fine. Let them go through that process. But not murder committed by a mature adult. Murder in Connecticut has a minimum of 25 years. That's for a reason. These are deliberate, violent acts. On top of that, when the Carlson family was notified that the person who murdered their daughter Elizabeth was requesting a commutation, they had only 5 days to respond. 5 days to get over the shock of this, get their thoughts together, to prepare a statement, to get statements from other supporters. The murderer has plenty of time to get the paperwork done, to get whatever is required by the board. The surviving family members had 5 days. It's another outrage. We are not talking here about convictions that were questionable, that were made on shaky grounds, the kind of crimes that the Innocence Project works to overturn. No one wants to see an innocent person incarcerated. That is not what we're here for. We are talking about people who were convicted with solid evidence, who did in fact commit the crime for which they were convicted, including the person who savagely murdered 3-year-old Andrew 16 years ago. During the 3.5-year-long legal process that eventually led to the plea agreement, I learned of the word ineffable. Ineffable means something that is beyond description. Something that cannot be conveyed in words. I have now spoken with many people who have suffered through the murder of a loved one. Each of them has described some version of ineffable feelings. Some version of, I just can't find the words. It is bewildering, and it is maddening. And I genuinely hope that none of you ever has to know those feelings. I am asking, we all are asking, that the Board of Pardon and Paroles pause the commutation process. Consider these concerns. The commutation system must be more transparent. The public has no idea how it's currently run. It is one of several ways that sentences can be shortened. The people should know that there is a threat to justice, there is a threat to public safety, and that it can be avoided starting right now. Thank you for being here today, for allowing us to speak, for listening to us, and for helping us work to improve the complicated and sometimes unjust criminal justice system. And I'd like to introduce Leslie Schlachter.
Thank you all for being here today. My name is Leslie Carlson Schlachter, and my sister Elizabeth was murdered 21 years ago by her ex-boyfriend, Dr. Jonathan Carney. He was a doctor. I was at my sister's side the day that Jonathan stalked her and then shot her to death in my family home. I had to run for my life to escape him as he reloaded his gun. After the murder, during the investigative process, we learned that her murder was carefully planned and prepared for. As you heard before from my mother, both sides agreed to a plea deal where he would be incarcerated for 42 years without the chance of parole. The opportunity for commutation of his sentence in any manner was never an option brought to our attention. When a plea deal is agreed upon by both parties, it should take away fear and uncertainty for the victims' families, and it should take away hope for an early release for the offender. Commutation directly undermines the definition of a plea deal. Think about this for a moment. The prosecution and the defense worked tirelessly for months, even years, during this process of plea bargaining to come to a final plea deal. This should be binding. The Board of Pardons and Paroles has a set of requirements for application for commutation. On the policy, there is a set of requirements to apply for commutation. However, somehow the requirements do not include recognition of a mutually agreed upon binding plea agreement. That's why we're here today. Like I said, we believed we had a binding agreement only to find out there are loopholes. This changed our stance on the plea agreement completely. If we had had this information prior, we might have gone to trial, and Jonathan might have received a sentence of 60 years. So what are we doing about this? That's why we're all here today. I have specifically asked for these exemptions. The Board of Pardons and Paroles on their website does accept amendment requests, and they accept them through the mail. And this is what we have requested. We, meaning my family. We have asked for them to exempt anyone where the applicant has accepted a plea deal for murder or capital murder with both crime and plea after the offender's age of 25. We have also requested that the applicant those applicants be exempt if the applicant has had an application for commutation denied by a panel or revoked within the last 5 years. It currently stands at 3 years. The reasons we're asking to exclude a plea deal for murder over the age of 25 is that there's well-accepted research that has shown that anyone over the age of 25 has brain capacity and is mature enough to understand the consequences of their action, meaning the act of murder and the act of accepting the plea agreement. We also strongly believe that the victim's family should not have to be subjected to this process on a 3-year cycle. We believe that a 5-year cycle is more appropriate. We hope that the Board of Pardons and Paroles approves our amendment request. Well, first we hope they pause, and then we hope that they would consider our amendment request, as we believe it represents who should and should not be considered for commutation. It also creates transparency not only for the applicant, but for the victims' families. I'd like to introduce Senator John Kissel. Thank you.
All right, so I'm not going to pull any punches. This is outrageous. I've been honored to serve in this legislature for the last 31 years, and this just came to my attention because some victims who were undergoing this process reached out to Senator Summers, and she brought me in to learn about what was going on. I have served for the last 29 years on the Judiciary Committee, where I have been for decades the ranking senator, and when we were tied, I was co-chair of the Judiciary Committee. We weren't apprised of what was going on. I'm going to tell you right now, 3 of the bravest people that I know are the lay people that just got up here and spoke. Look around this room, all of you. Think about one person in your life you love. Think about how hurt and devastated you would feel if somebody with premeditation in advance committed a horrible crime and either murdered them or mutilated them. And to avoid having to relive that trauma in a trial setting, you work closely with the state's attorney and hammer out a plea agreement so that you can put this tragedy behind you as best you can, even though you know you can never fully get it out of your head. And also in your heart of hearts, you don't want to forget the loved one. You owe them the good memories. So now, all of a sudden, we get the Board of Pardons and Paroles saying we're going to do this. And also, if they deny it under their own self-same rules, they get to reapply in 3 years. Now, let's just take a break. Let's just step back, because I am absolutely appalled, devastated by what I've learned. And I am calling on Governor Lamont, stop this right now. This needs to be a state policy that is rigorously overseen. The legislature has got to weigh in. Why has the numbers gone from 1 to over 70 in 1 year? Why? And what does this say to our judges that we vet and that we go through this rigorous analysis after 8 years as to what they did on the bench? They struggle. I have talked and reviewed every single judge in the state of Connecticut, either on their first appointment or on their several other appointments every 8 years, because I've been here for 30. The ones that serve on the criminal side struggle with sentences. And now, 3 unelected individuals that are proposed by the governor that will come before the judiciary, and we just pass on them, not even attorneys, not that you have to be one, review these individuals and decide, and the average I've learned is 15 years commutation. That is time taken off their sentences. Who in the public is really aware of what's going on? And why did it go up? Why is the applications, as Senator Kelly said, this is only 10%? Because if you're sitting in prison, this word goes like wildfire. Anybody's going to apply for this. And the Board of Pardons and Paroles have said, well, you got to be in there at least 15 years. 15 years for what you heard? That is not justice in the state of Connecticut. We need a real heartfelt analysis of what we're doing here. So please, Governor Lamont, listen to us, listen to the victims and their families. Stop it right now. And if I had my way, I'd pull it right out of the pardons and paroles. I'd have a rotating 3-judge panel. But that's just me. I think these people are being too nice in their requirements for having some of these people pulled back from the process. I learned, and I'll leave you with this, I actually learned that when someone is sentenced to life without possibility of release, even that hasn't been absolutely taken off the table. Why? Because no one's watching the rules. We have a committee that is bipartisan, regs review, of which this year I happen to be co-chair, and there's no regs on this process. There's nothing that we're reviewing. They've made these rules up on their own, and there's no oversight that I can see but Governor Lamont. So I implore the executive branch and Governor Lamont, for these individuals and everyone else in their shoes, think about it. Would you want to relive this process every 3 years if it got denied the first time? But apparently the gate's wide open right now. This is outrageous. And at that point, I mean, I'm just really upset. So I'm going to turn it back over to Senator Summers and Senator Kelly. But this is not small potatoes. This is how everybody in Connecticut is going to look at our judicial system. This is wrong.
So I'd like to just thank Audrey, John, Leslie, for your stories and for your courage and willingness to be voices for victims and to bring this message forward. I'd also like to thank Senator Summers for her leadership on this issue, and obviously Senator Kissel's remarks. Also standing with us this morning are Senator Henry Martin and State Representative Laura Dancho.